Thanks for joining today's presentation and new webinar series brought to you by the SLW Institute, which was developed by the Schwegman firm to deliver educational and training content to help advance your IP knowledge. My name is Brian Ness, and I'll be facilitating this webinar series. This series is going to be presented by Schwegman's Chem Bio Legal team, and their goal is to provide practical tips to companies and universities looking for an understanding of a new patent area or a new era of patent law to protect IP in chemistry, pharmaceuticals, biotech, and genetic medicine. For today's presentation, Drs. Robin Chadwick and Ricardo Moran will explore the post-Myriad patenting environment and analyze how the courts and the patent offices, or the patent office, has come down hard on claims directed to natural products and diagnostic methods, and provide suggestions on how to optimize your chances of obtaining commercially valuable and defensible patent claims. Robin and Ricardo, I'll let you introduce yourselves and take it from here.
Thank you, Brian. This is Robin Chadwick, and I have about 20 years of experience handling all types of biotechnology. I have a PhD from Yale University in molecular biochemistry and biophysics, and I did work in Manhattan for a while until I saw the light and decided to join Schwegman Lundberg Wuessner, where I've been happily toiling away ever since.
And my name is Ricardo Moran. I am a principal in the Chem Biotech group. I have been at Schwegman for the past 5 years, I'm sorry. I'm a PhD organic chemist, and I've been practicing pharmaceutical patent law for almost 18 years at this point, mostly in the East Coast and Washington, D.C. based law firms. But like Robin, I saw the light, and like I said, I've been at Schwegman for 5 years now.
So this is Robin again. I thought we should start maybe looking at a few statistics, and these statistics were provided in a case list that was an addendum to a patent office report issued in July 2017 here. The list apparently was put together so that it would be useful for examiners. But they listed 82 Federal Circuit cases, and 12 of those cases were listed as having patent eligible claims, at least one patent eligible claim. So that's a success rate, if you're looking at this from the patentee's perspective, of about 13 or 14%. 10 of the 82 cases were life science cases, and 3 of those 10 had at least one patent eligible claim. So if you can look at this as being statistically significant, it looks like maybe the life sciences cases are doing a little better than average. So we can take some hope in that.
Yeah, and one of our take-home messages today, of course, will be that we're hoping that some of the advice that we provide today will help you at least be sort of on the winning side of that. So one of the things that I'll talk first about is, patent eligible subject matter in the area of natural products. I think historically, at least in my field of organic chemistry, a lot of innovation, a lot of discoveries have been in the area of natural products as as therapeutic agents. Okay, so I think everyone's familiar with paclitaxel, which is an anti-cancer agent, and there's been a heck of a lot of innovation in those areas. Just basically getting at natural products that are produced by organisms. Okay, and one such natural product we'll talk about in a little bit. But no matter what area of technology you're working in, there's always going to be a two-part test for patent eligibility. The first part of that test answers this question: are you dealing with a product of nature or some sort of natural correlation? And even if you are, okay, and if you get past that first part of the test, you could still fail, but we'll help you succeed in that area in showing that even if you are working with a product of nature or natural correlation, if you're able to show that there's an invented concept that is significantly more than the law of nature, you could still succeed in getting patent claims issued. So back to natural products, and one such naturally occurring compound, it's called Teixobactin. It's a compound that's isolated from soil, and it's produced by a bacterium. And the patentee, or the applicant in this case, sought to protect this natural product, but in a very different construct, which was in the context of a pharmaceutically acceptable carrier that effectively solubilizes the compound. And the applicant in this case reasoned that, well, if we make our claims look like some of the examples that the Patent Office has promulgated for basically giving examples of what constitutes patentable subject matter, then we should succeed. So what they did is they put together that claim that you saw on the previous slide, claim 54, because it was analogous to this example in the guidelines for the Patent Office, which says, if you take the natural product, in this case amazonic acid, and a solubilizing agent, that constitutes patent eligible subject matter. Unfortunately, the Patent Office, I guess, maybe is not in the business of following its own guidelines, and so they decided that still did not constitute patent eligible subject matter, because they reasoned that you could still have this compound be soluble in water. And as most of you know, most of the compounds out there, you find them in some solution of water. So they reasoned that the Patent Office reasoned that it was not patent eligible subject matter. So in this original case where you found this compound, not compound, but claim 54, the applicant eventually canceled all the composition of matter claims and just simply went for methods for treating infections in the parent application. Interestingly, later, they were able to get claims to compositions of matter that were substantially identical. Specifically, claim 54 was identical to the one that was presented in the parent case. But the way they were able to achieve that was that they were presented evidence on the record that these compounds, Teixobactin compounds, were not very soluble in water, and that they were soluble in these non-naturally occurring excipients. At the moment, they have some methods of making claims pending in a second child case, and surprisingly, these are rejected under 101 as of this month. So we'll just keep looking at the record there just to see what develops there. So here are some take-home messages based on this very simple example that we've chosen from the real world. I think that some of the take-home messages from the Teixobactin cases shows that if you combine a compound, a pharmaceutically acceptable carrier that is not natural occurring, you'll have much greater chances of getting a patent claim to that composition. The other thing that we've learned is that you're going to, in some cases, you're going to have to submit some sort of evidence that it shows that these compounds are difficult to solubilize in water, so that you can show. And I think this actually goes to the second part of the test for patent eligible subject matter, is that the composition has to be more than what is naturally occurring. Now, one of the things that I did not see in the record of the Teixobactin line of cases was that they did have certain chemical modifications that they had made to the parent compound, and for whatever reason they haven't prosecuted those claims. But I suspect, however, that if you make chemical modifications to the natural product, to the parent compound, and you're able to demonstrate that maybe those modifications make the compound more active, more soluble, or somehow improve the compound, then I think you're going to have a good chance of getting a patent claim to that compound. So what works based on this example is that you're going to have to add something unnatural to your claims. Whether that's combining products not found together in nature, that's one thing, or you can chemically modify your natural product to make it basically look nothing like what is found naturally in nature. So at this point, I'm going to turn this over to Robin to discuss sort of the other side of this, or sort of the biotech side, where we explore diagnostic claims.
Thank you, Ricardo. Next slide. So I'd like to turn back to that Patent Office report just for a few minutes here. So if you recall, there were 10 life science cases that had at least one patent eligible claim. And no, there were 10 cases, life science cases listed, but 3 of those had just one patent eligible claim. So what's the story with those 3 cases? Can we learn anything from them? Well, one of the cases that did have a patent eligible claim was the Klassen case. And here we have methods of immunization scheduling. So basically, the patentee had written claims to optimizing or reviewing immunization schedules, and then choosing the right administration schedule, the optimal one, and then administering along that schedule. So this looks more like method of treatment type claims than a straight diagnostic claim, but that might be one option for us. In another case, the Cells Direct case had patent eligible claims directed to cryopreserving hepatocytes. So there were cycles of freezing and thawing these cells. So this doesn't look like a diagnostic claim at all. This looks like a sort of a manipulation of matter claim. And in the Myriad case, the claims directed to analyzing or comparing DNA sequences were all held to be ineligible. You may recall that. But there was one claim that was found to be eligible, and it involved a method of screening for therapeutic agents. So again, here what we're doing is we're manipulating things. We're not performing a diagnosis. So one thing we might learn, next slide, is that if we make our claims look like they're not a natural correlation, we're not going anywhere near a diagnosis. So let's try to make our claims look like there's something just involving manipulation of matter. Then we can answer no to the first part of this 2-step test. And we don't even have to move into the second part of the test. So next slide. Let's look at an example here. So here we have an example of a claim that was probably filed years ago. This is the Cleveland Clinic case. And we have a method of assessing risk of cardiovascular disease. And the one active step involves determining the levels of myeloperoxidase. And then we have one of these wherein clauses, which we know from the Prometheus case is not necessarily the best way to go forward. The Prometheus case had a wherein clause similar to this. And here we have wherein elevated levels of myeloperoxidase indicate that the subject is at risk for cardiovascular disease. And what did the court think about this? Well, as you may predict in the next slide, the court didn't like it. The court basically said, the district court said that the claims merely allow one to see the natural correlation of myeloperoxidase correlated with cardiovascular risk. The claims did not add something more that transforms the natural correlation into a patent-eligible invention. And so that type of claim fell and was no longer eligible for patenting. So let's look at another example. And this is from the same Cleveland Clinic case. Here we have a method of administering a lipid-lowering agent. So now this looks like a method of treatment claim, sort of like the Klassen case maybe. And here we perform an ELISA assay to determine myeloperoxidase activity levels. And then we select a patient that has elevated levels of myeloperoxidase. And then we administer the lipid lowering agent. Now, what did the court think of this? Well, this claim apparently survived a 101 type issue, but True Health, the defendant, alleged that Cleveland Clinic had never stated a claim for infringement. So the court looked at the infringement issues. And they had to consider contributory infringement and induced infringement because Truth Health, the defendant, was a testing lab. All they did was receive samples, test them, and then report the results. So is this a sort of situation that would allow for contributory infringement or induced infringement? And here are the standards for us. If you remember, contributory infringement involves a case where a party sells or offers to sell a material or apparatus for use in a patented process. And in induced infringement, you have to have somebody who directly infringes the claim, somebody who performs all of the steps of the claims. So next slide.
So this Robin would probably underscore the importance of preparing claims that are infringed by a single entity.
Yes, it does, as we will see sort of in the next slide, because the court found that there was no contributory infringement. The lab reports that True Health Diagnostics provided were not a material or apparatus that was sold by True Health. I mean, one might argue they are sort of a material. You're handing off a piece of paper, but that wasn't sufficient. And the court also found that True Health did not sell or prescribe lipid-lowering drugs. All they did was test to see what the levels of myeloperoxidase were. So in this case, there was no induced infringement. So while method of treatment claims might survive a 101 type hurdle, they may not be the best tool to assert in an infringement proceeding against certain types of defendants. Next slide. So what can we do? Well, here's an example. We have, and this is the Oxford Immunotech versus Quiagen case. Here we have a method for diagnosis of tuberculosis. And the method involved incubating T cells from the host, the subject, with a panel of peptides, and then detecting whether the T cells recognize the peptides in the panel. Now, this looks like a nice little assay, doesn't it? I mean, this is what I'm trying to tell you to write, but unfortunately, the court still found that this claim did involve a law of nature. There was a natural correlation going on here. But when they moved to the second step, the patentee was able to prove that the results of this test were an improvement over existing technologies. The test was more convenient, it was less dependent on physician subjective interpretation of results, it was more accurate, and so this claim survived the motion to dismiss. Now, the litigation is still ongoing apparently, so I don't know if the claim is still alive and well, but at this point, that's an indicator that this type of improved results may be an avenue towards surviving a 101 rejection or a 101 challenge.
And it only can help you in the long run anyway to have such evidence, right? Because as we saw with the, at least with the natural products, right, Robin, that that can help you with, it can also help you with patentability.
That's right. Yes, and so it's beginning to look like 101 type analyses and arguments are basically, Section 103 obviousness type arguments. So what can we do when we have diagnostic claims? Well, let's try to make our claims look like, there's no natural correlation going on here. We're just writing a little assay claim, something that manipulates matter. We're doing active steps like measuring things. We're not really doing anything in our mind that is, the key step here. Sometimes you can't write your claims that way, though. Sometimes you have to include some sort of correlation or algorithm in your claims. And in that case, you do need to add significantly more to the claim. So you may be forced to add things like new reagents. You may be forced to add new assay type steps. Or, as we just discussed, you can try to show that you have improved results over existing technologies. Next slide. There's still a ray of hope here because there are a number of entities who are looking at proposed amendments to Section 101. And I'm showing you just one example here. This is from AIPLA. And here we have what AIPLA has done is sort of add a couple of, subparagraphs to Section 101. But significantly, in the first sort of line of Section 101, they deleted the word new. And so what Section 101 now says is whoever invents or discovers a new and useful process, etc., machine, manufacture, etc. What AIPLA is proposing is to delete the word new. So now the focus is on useful. And that's a very good thing for people who want to get over 101 hurdles. The other thing to note potentially is subparagraph B, where this proposal defines what would be ineligible. Only if a claimed invention as a whole exists in nature independent of and prior to any human activity, or it can be performed solely in the human mind, would that claim be held to be ineligible. So if these types of amendments are actually, if we can get them through Congress, which doesn't seem likely in the near future, a lot of our problems will go away, because things like the types of diagnostic methods that we just looked at would potentially be allowable, and even natural products that have been manipulated in some ways would also be allowable.
Because they would be useful processes.
Yeah, because now the focus would extract this whole, sort of argument, this whole analysis from sort of a 103 obviousness type analysis into and place it back in the useful sort of category that it used to sort of be before, the Prometheus case and some of the others, the Myriad cases.
Right. And you can duke it out in that, the arena where it should have always been.
Right, where we think it should have always been.
Yeah, right.
All right, so so just in summary then, 5 tips for patent prosecution if you're dealing with natural products and diagnostic claims. For natural products, as Ricardo was saying, add something unnatural, combine the products if they're not found together, combine various products if they're not found together in nature, chemically modify the natural product. If you're dealing with diagnostic claims, try to draft them as though they were assay claims. Add new reagents or steps, and try to show that you have an improvement over existing technologies. And that's all we have for today. We're happy to take some questions.
Well, you know what? Let me start with a question, Robin. There are kit claims in the Oxford v. QIAGEN case. Would you comment on what happened to those kit claims and whether kit claims are an option to survive a Section 101 challenge?
Right. So the kit claims in the Oxford case, if I remember correctly, involved just a panel of peptides that were taken from the ESAT6 protein. And so these little peptides were not the same as the natural product, because they were just little pieces of it. And yet the court still held that they were natural products. It was analogous to the Myriad case, where breaking of chemical bonds did not make the little peptides into a new thing that was eligible for patenting. And unfortunately, the kit didn't. Well, I believe there were actually dependent claims to, the peptides on an apparatus, some sort of generic apparatus. And that sort of generic, type addition to the peptides themselves was not sufficient to, was not something more that elevated the claim to patent eligibility. So we needed to do something in addition to just having the peptide sitting in a little, glass of a little vial. You might consider labeling them, but again, those standard nowadays is routine and conventional. If people, routinely and conventionally label things or attach them to, a solid surface, that I would think that would move them beyond being a natural product. And yet, the dependent claim in that case wasn't sufficient to move it into sort of patent eligibility.
Thanks, Robin. The other question I have for you is that Athena v. Mayo. Okay, that decision was handed down by the Massachusetts District Court. Can you just say a couple words about that case?
Yeah, so if I recall correctly, this involved diagnosis of myasthenia gravis or some other neurotransmission disorder. And what the main claim recited there was that basically they were just detecting autoantibodies against a specific antigen that was sort of made naturally in the body as a result of having this disorder. And the autoantibodies, so the main claim just said basically, you know, detecting these autoantibodies against, I guess the antigen was some sort of kinase. And that was not held to be sufficient. Even though, you know, well, the other problem with the claim was that it said a method for diagnosing neurotransmission disorders. So we don't want to talk about diagnosis at all. That immediately flags this as something that contains a natural correlation. But people had argued that because in some of the dependent claims, you know, reagents like labeled, you know, antigens were used to look for these autoantibodies, that those claims should have been held to be eligible for patenting. But the court denied that because, again, they held that those are sort of routine and conventional sort of ways of doing assays. And so, unfortunately, those claims were held to be ineligible for patenting by the district court in Massachusetts.
So, Robin, we have a couple of questions coming in. The first one is, I'll just take them in series, actually. It's more of a statement / question. It says, so do these proposed legislative changes in 101 by the AIPLA, does that make US law more like, quote, technical effect in Europe?
Well, you know, I'm not as well versed in European law as US law, but, you know, it does seem like European law is more sensible in the way they approach these things. I don't know. What do you think, Ricardo?
Well, the thing is that, you know, when you're talking about technical effect is that I think that even without these changes, I think that maybe that is the rule of reason, right? It should be more of a technical effect when you're trying to distinguish over the art, right? That's what the technical effect is ultimately. Is that, you know, there's these differences that are associated, the differences between what you're trying to claim in the closest prior art, and that technical effect solves the problem, basically. So I don't think that those changes in 101, I don't think they move our law closer to sort of the technical effect in Europe.
Well, if the focus is on utility, then, you know, to some extent we have a sort of technical solution to, you know, some problem maybe. And in that respect, you know, it might be a little closer. So I'm not sure we answered this question, you know, perfectly, but.
And I'm not, yeah, and also I'm not sure that it does move it in that direction anyway.
Yeah.
The next question is, can you give an example that illustrates the distinction between a diagnostic claim and an assay claim besides adding active steps?
Well, you know, I find that the courts are a little bit all over the place in terms of finding laws of nature and natural correlations in things that look almost like assay claims to me. And I've tried in my own work to sort of add, you know, active steps to my claims. And, you know, once the patent office gets their teeth into something that they think involves a natural correlation, it gets pretty tough. So, you know, obviously you want to avoid things like, you know, a method of diagnosing, a method of even detecting a disease, you know, can flag the claim to, you know, be held to have a natural correlation.
Right.
And, you know, it's hard to retreat from that once you've sort of gotten your claim put in that bucket. Now you do have to show something more.
Right.
So, yeah, so repeat the question again. Maybe we can expound on this a little better.
So can you give an example that illustrates the distinction between what constitutes, you know, a diagnostic claim and an assay claim besides just adding the active steps, right?
Right, yeah. So, you know, if you can just add enough. Well, it's almost like doing the second step. Adding something more. You're basically, making the claim look like, you're just detecting something. You're looking for something, and you're finding it by measuring something, by mixing things together. You're manipulating things, like sort of in the Cells Direct case. Oh, we're not really doing diagnosis here. We're just, manipulating matter. And, unfortunately, when it comes to the end of the claim, you have to detect something. Then, that immediately flags the claim for potential 101 rejection.
So maybe
it's hard.
Another example is just basically manipulating matter is what distinguishes a diagnostic claim from an assay claim.
Well, I would say an assay claim is more of the manipulation of matter. It involves physical steps of mixing things together.
Right.
Whereas in the diagnosis, it looks more like, your brain is just doing the analysis here or something.
Right.
And, you're just seeing the natural correlation. You don't want the claim to look like you're just seeing a natural correlation.
Okay. So I'm going to move to the next question. With respect to the Qiagen peptide claims, couldn't they argue that the peptide was not found in nature? I'm presuming they were made synthetically.
Yes, they were made synthetically, and that was one of the arguments that was made, but that wasn't sufficient. And, it's sort of like, I filed some cases that involve using primers. It's very hard to get the primer itself allowed. You can't do that because even though it's a little piece of something and its utility is completely different from, the original molecule from which it was, sort of cut out of, that primer or that peptide is not held to be eligible for patenting these days. You have to, you can add maybe a label to it, but, for example, was it the Athena case again? Yeah, the Athena case where they put a label on the antigen, and that was held not to be eligible for patenting because that's routine and conventional.
Right.
So, and in the Athena case, I believe, they had this apparatus that, would be part of the sort of, thing with the kit with the peptide, and that was held not to be eligible for patenting. So it's getting tough. You have to, I think, Ricardo, you and I were talking a few days ago, you have to almost have a second invention in your diagnostic claim.
Right. If you're going to go for a diagnostic claim.
Yeah.
Right. So I guess that's another tip in some ways, right? This is that if you're gonna be hell bent on getting a diagnostic claim, you better have something else in there that is also patentable.
Yeah, or just shows, sort of surprising result type things. Maybe that helps.
Right, and I've seen situations where patent applicants have tried to, in the context of a litigation, they have tried to change, show. Well, not in the context of litigation, in the context of prosecution, they've tried to add like certain steps that involve labeling and a specific instrument and all that stuff, which was sort of the old advice that people were giving, let's say about like 5 or 6 years ago, and that has proven to be ineffective actually, because of this routine.
Yeah, the test again is routine and conventional. If you look at the Patent Office guidelines, there are examples where, the Patent Office says something is eligible for patenting because, for example, a specific type of antibody, antibodies from, goats or something, were used to detect instead of antibodies from mice, or, that's what they said. Now, whether that's, going to hold true when we're trying to do it, we're trying to assert these things.
They haven't been shown to follow their own guidelines. So here's another question. How is a treatment step assessed from a contributory infringement claim?
Well, so, what was the standard again? The defendant has to, sell or offer to sell. I wrote it down here, but I'm not sure I have it in front of me. Yeah, sell or offer to sell a material or apparatus for use in a patented process. So, if you're a testing lab, a diagnostic testing lab, you know, you're not selling or offering to sell a material or apparatus for use in a patented process. I mean,
Right.
you know, again, I think one might argue that the knowledge, the report could almost be a material that, you know, would be used in the patented process, but that's not what the court held.
Right.
Now, I believe these claims, you know, well, they could be appealed, though it was a federal circuit case. So
Right.
we'll see what happens.
So here's another question. What about using in a preamble, quote, identifying a subject characterized as having ... you know, comma, wherein, you know, as having cancer, let's say.
Yeah. Identifying a subject. You know, I mean, that looks a little bit like, you know, one of the claims we looked at, you know.
It's a Klassen, right?
Yeah, Klassen and or, you know, the Cleveland Clinic, where we, you know, we had a method of administering the lipid-lowering agent. So yeah, a method of identifying, that might actually, I wonder about that, because you're in essence, you know, as a diagnostic testing lab, are you identifying the patient that might benefit from, you know, some treatment? I mean, maybe that could be, you know, an avenue towards, you know, patent eligibility there, because, you know, if you, you know, are providing the information that then allows the treatment to proceed. But, you know, the problem there is that if the diagnostic testing lab is not administering the, you know, the medical treatment, then, you know, you're still sort of stuck from a,
yeah, you're in a Cleveland Clinic situation.
Yes.
Right.
Yeah, exactly.
Right, where you're not infringing, even though you passed the 101 scrutiny.
It's all in the nuances of wording somehow, and it's very fact dependent. So you have to be, you know, you have to stare at your facts and think about what you can assert here.
Awesome. Well, I think that's all the questions we have today. If anyone in the audience has any questions specifically for Robin or Ricardo, feel free to connect with them directly. Again, a recording and a copy of slides will be available tomorrow, and everyone should receive an email with a link for that. After we end today's webinar, you should get a prompt to register for the next one if you choose to do so. Our next one's going to be on October 5th at 1 p.m. Central, and it's going to be how to maximize protection, patenting inventions, including chemical features. Thanks again to everyone, and thank you, Robin and Ricardo. Bye now.